ஸ்டார்ட் பண்ணிக்கிட்டா no phones, no phones. Once if you come into the class, please follow some etiquette of the class. Please sit down. Start. No. It may be there is some sort of etiquette is being attached to the class, right? Yeah, please listen to the class. Please listen, right? Yesterday we are discussing about different forms of last cabinet. Enna? Last yeah, please settle down. Please settle down. Once you come into the class, have something. You have take with you something. என்ன கன்னட சார் நீ வைமாக்கு வா சொல்ற. No. You have time to spend with so many activities. You don't what is called find time to come to the class and attend the class. Thinking that you are thinking I will do some other things. Please, yeah. Now I know. Whoever is coming to the class, don't think. Normally, வைமாவில் என்ன பண்ணுவேன்னா ஃப்ரீயா இருப்பேன். But if I remember your faces, your Viva goes for 6 days. If you come for Viva, you will come in the afternoon. Again afternoon, tomorrow morning. Again, tomorrow afternoon. 6 days I will make you to run. Don't think that it is over for this class. I am student friendly, but sometimes if I am harsh, things will be something different for you. Literally, you will try in the Viva. 6 நாள் tenors வா, நீ வைவாக்கு வா. I will see. 6 days Viva for you. No. அவனுக்கு தெரியும் நான் எப்படின்னு சொல்லி. திவாகரங்க. ரைட். சார் நீங்க எனக்கு மார்க் தெரியும் உங்க பத்தி ஏன் சொல்றான் அவன். No, please. Once if you come into the class, இத்தனை நாள் எப்போ படிக்கல. Since what is called 9 semesters, 5 semesters, you didn't read anything. At least learn something. இன்னொரு 10 நாள் தான். 10 நாள் ஆனவட்ட நீ யாரோ நான் யாரோ. Viva வரைக்கும் maintain that things. Once Viva is over, even you need not wish me also. Right? You can go. Yeah, please. Right. So we will see content of the arbitration agreement, how the arbitration agreement comes into existence. Right. Yeah, please. Right. So, you know, hello. Ella. Right. So it's primarily a contractual nature, arbitration agreement being primarily a contractual nature, it requires consent of the parties for arbitration to happen. Normally, whenever you are entering into the contract, from the intention of the parties, you can gather the intention of the contracts. But in arbitration agreement, you cannot gather their consciousness from their intention. That means, for arbitration, compulsorily agreement should be there, right? So, being primarily of a contractual nature, arbitration requires the consent of the parties for arbitration to happen. Arbitration compulsory or agreement irukano, that agreement should be, again, you have to follow all essential conditions of Contract Act. Free consent. When consent is said to be free, when there is no undue influence, coercion, anni kuda. Arbitration agreement also requires free consent of the parties to enter into the agreement. The arbitration agreement thus becomes the foundation stone on which the entire arbitration proceedings can consolidate. Right? It's a contractual process, requires free consent of the parties to arbitrate. Contract Act ஒரு కాంట్రాక్ట్ లో ఎంటర్ కావాలి అంటే ఎలా ఫ్రీ కన్సెంట్ ఉంటుందో అదే మాదిరి ఆర్బిట్రేషన్ అగ్రిమెంట్ లో కూడా ఎందరుకున్నా ఫ్రీ కన్సెంట్ షుడ్ బి దేర్, రైట్? If there is no free consent, you cannot gather the intention of the parties to arbitrate. Straight away, you cannot go for arbitration, right? So, the arbitration agreement is the foundation stone on which the entire process consolidates, right? Arbitration cannot take place unless there is a valid agreement to arbitrate between the parties. Now we will see. All right. Now, first point, that a party have expressed their consent to exclude the jurisdiction of the courts, right? You know, jurisdiction is conferred by statute. Jurisdiction is conferred by statute. That means law confers the jurisdiction. You cannot oust the jurisdiction by your consent. Jurisdiction ante oka chattam dwara oka jurisdiction istar. For example, if there is a dispute in Tirupati, compulsory you have to go to Tirupati courts only. That means Tirupati court is having the jurisdiction, right? By your consent, you cannot go to some other place. Jurisdiction ni meeru మీ consent ద్వారా you cannot exclude. But in arbitration agreement, you can exclude the jurisdiction. That means dispute is in Tirupati, you can sit for arbitration in Chennai. That means you are consenting to exclude the jurisdiction. Normally, jurisdiction என்றது உங்க கையில கிடையாது. That has been conferred by the statute. For example, different types of jurisdiction is there. Pecuniary, territorial, subject matter jurisdictions are there. Normal cases, you cannot exclude the jurisdiction. But in arbitration agreement, dispute can be in one place. Even you can have the seat of arbitration in London also. Yes, you can oust the jurisdiction. Arbitration the main point என்னன்னா நீங்க எங்க உட்காரலாமோ டிசைட் பண்ணலாம். இங்க dispute இருக்கு. You have entered contract in Tirupati, but you can go to Singapore. Arbitration. Yes, you can go to Singapore and sit in a hotel and you can do arbitration. That means you can oust the jurisdiction. That's what says. Party have expressed their valid consent to exclude the jurisdiction of the court, which is a part of their essential right embodied in almost all the constitutions of the world, and submit their dispute, which is effectively a private process of dispute resolution. Right. Now, it's a document. It's a document which brings overall subtlety to the arbitral process by ensuring the type of arbitration, terms of the process. You are selecting in the arbitration agreement jurisdiction, whether you are going before a private adjudicator or whether you are going before an arbitral institution. So, everything will be contained in the arbitration agreement. Next one, it provides the jurisdiction of the tribunal and source of the power of the arbitral tribunal in supplementing the law governing the arbitration. புரியல.
நேற்று குரூப் கோர்ட்டுக்கு சொல்லியிருந்தாங்க சார், அது இப்பயே போகணுமா இல்லை?
எனக்கு தெரியாதுமா.
கீழே மட்டும் கேட்டுருக்கோம்.
போய் டுடே யூ ஆர் ஹேவிங் கோர்ட் விசிட்டா? ரைட். கிளாஸ்ல இருந்து வெளில போயிடணும். ஃபர்ஸ்ட் கோர்ட்டுக்கு போய் ஜஸ்ட் யூ ஹேவ் யூ ரோம் ஆல் அவர் கோர்ட்ஸ். கோர்ட்ஸ்ல யார் யார் எந்தெந்த கோர்ட்ல யார் யார் இருக்கா, எந்தெந்த ஜட்ஜ் இருக்கா, யார் யார் ஜட்ஜஸ் இருக்கா அப்படி பார்த்துட்டு கிளாஸ் தேவையில்லை. தென் the class and a secondary, right? Class is for a secondary for us. Frankly speaking, if you go to the courts also, whenever they are or advocates are arguing the case, honestly tell whether you are going to understand. Whether you are going to understand? தெரியாது. ஏன் தெரியாது? கிளாஸுக்கு வந்தாலே ஒன்றும் தெரியாது. இந்த கிளாஸுக்கு வரலன்னா இன்னும் தெரியும், ஒன்னும் தெரியாது. சும்மா அப்படி போயிட்டு அப்படி கோர்ட்டெல்லாம் திருப்பதி கோர்ட்டு பார்த்துட்டு then actually what happens whenever you are going to the courts, there are certain etiquities எல்லாம் இருக்கு. ஜட்ஜ்மெண்ட் எப்படின்னா அப்படி பிஹேவ் பண்ணக்கூடாது, தெரியும்ல. லாஸ்ட் டைம் உங்க சீனியர்ஸ் misbehaved with somebody and it's a big issues has happened. கோர்ட்டுக்கு போனா you have to follow certain aspects will be there, right? Now it provides the jurisdiction of the tribunal, right? Second aspect, first aspect, by agreement you can exclude jurisdiction. By agreement you can exclude the jurisdiction. Second one, if you are entering into the arbitration agreement, it provides jurisdiction of the tribunal and the source of power. Even you can select the law also. For example, there is arbitration between American company and Indian company. The seat of arbitration is India. In the arbitration agreement, you can select whether Indian Contract Act of India will apply or that American Contract Act will apply. You can select the law also. Governing law you can select in the arbitration and both the parties has to accept. For arbitration agreement you can select the law, governing rules also you can select. Now, once parties have expressed their consent to arbitrate, right? Once they have expressed their consent to arbitrate, they cannot unilaterally withdraw from arbitration. Urvani arbitration and agreement la enter ayyaru ante subsequently you cannot withdraw from the agreement. Right. Now assume that you have entered into the agreement for arbitration. ఒక అగ్రిమెంట్ లోకి ఎంటర్ అయ్యారు, ఆర్బిట్రేషన్ చేసుకోవాలి పన్నును சொல்லி you have entered into an agreement. One party refused to come for arbitration. Then what you are going to do? You understand my question? You understand my question? Two parties have entered into an agreement. For what? To go for arbitration. Now, one party is withdrawing that I am not going for arbitration. Then what happens? Huh? What happens? Award. Arbitration జరగలేదన్నప్పుడు అవార్డు ఎట్లా ఇస్తారు? He is not coming for art. There is no ex parte awards. There is no ex parte awards. One person is not at all coming before the arbitration. No proceedings has been taken before the arbitration. How unilaterally arbitrator assuming the power and jurisdiction can pass an award? Again, you go to Indian Contract Act. If one person withdraws from the agreement, what is the remedies for breach of contract? What is the remedies for breach of contract? For example, A and B enter into an agreement. You understand? A and B enter into agreement. A withdraw from the agreement. B wants to execute that agreement. What B is going to do? Specific performance of the contract. Specific performance. You don't know the specific performance of the contract. தெரியுமா specific performance என்ன? எனக்கு அக்ரிமெண்ட் அவன் என்டர் ஆனான்னு சொல்லி கோர்ட்டுக்கு போறோம். அதே மாதிரி எங்க போவான்னா கோர்ட்டுக்கு போவோம். You have to understand the legal aspects. When one person has withdrawn from the arbitration agreement, he is not ready to go before the arbitrator. The other arbitrator has no option to approach the court. Court will ask you go to arbitration. This is how technical things will come. As per Indian Contract Act, specific performance. He is going before the concerned district court, concerned high court or wherever. He is asking the court to enforce the arbitration agreement. You know, contract has been entered into by consensus ad idem. If any person withdraws from the consent or whatever it may be, court will enforce that agreement. Likewise, court will enforce the arbitration agreement. This is a contract now. You are by consent, you are entering into the agreements. You understand? Right. Once parties have expressed their consent to arbitrate, they cannot unilaterally withdraw from arbitration. Withdraw பண்ண எங்க போறோம் நம்ம கோர்ட்டுக்கு போய் கோர்ட் அசிஸ்டன்ஸ்ல arbitration வர சொல்லி கேட்போம். Again, one రాలేదనుకోండి, again he can challenge the different aspects. Again, if he is not coming to arbitration, he can challenge the order of the court. Right? That is another aspect. Now, agreement to arbitrate is a universally enforceable agreement. Once you enter into the agreement, you are bound by that agreement. Right? If you are breaching the agreement, court will interfere. Right? புரியுதா? Technical aspect புரியுதா? Specific performance contract enforce பண்ணலையே arbitration agreement courts வந்து enforce பண்ணணும். You understand? Arbitration agreement, it does not mean that merely ousting the jurisdiction, you cannot oust the court's intervention. Two different aspects. Jurisdiction is only for seat of arbitration, not ousting. Even by, if you know CPC, by your consent also, you cannot oust the jurisdiction of the courts. ఇక్కడ ఏం జరుగుతుంది? ఎక్కడ ఆర్బిట్రేషన్ జరగాలో అది మాత్రమే మనం తీసుకుంటున్నాం. కోర్ట్ జ్యూరిస్డిక్షన్ యూ కెనాట్ ఎక్స్క్లూడ్ ఈవెన్ బై యువర్ కన్సెంట్. రైట్? కోర్ట్స్ విల్ ఆల్వేస్ ఇంటర్ఫియర్. ద మెయిన్ క్రక్స్ ఈస్ అండర్ ది ఓల్డ్ యాక్ట్ ఇట్ విల్ ఇంటర్ఫియర్ at any stage. New act only after passing the award. Again, it does not mean that it won't interfere middle of the case also. Under 151 CPC, they can interfere at any stage. 151 CP's inherent powers of the courts. Courts have inherent powers. At any stage, at any point, they can interfere. Right. Now, we will see the definition of arbitration agreement. So many international conventions and UN central model of law have defined arbitration agreement. The New York Convention 1958 has defined the requirements of arbitration agreement in Article 2. Right? Under the convention, each contracting state, that means if there is a dispute between two states, they are known to be contracting states. Right? Under the convention, each contracting state undertakes what? Recognize. If an award is passed in India, America courts also recognizing your award. If an award has been passed in America, Indian courts are recognizing your award. Why? They are signatories to this convention. If you remember CPC, enforcement of foreign award is there. Right? You are going to recognize foreign awards also. So under the convention, each contracting state undertakes to recognize and give effect to an arbitration agreement, right, when the following requirements are fulfilled. Some requirements are there. If you fulfill these requirements, we are going to recognize. America award pass panna, India recognize pannuva, India award pass panna, America recognize pannuva, again two countries have entered into an agreement, convention, they signed the treaty, we are going to recognize your awards. So award carry again, in award pass panni, anga recognize panlanna kuda, they can go for execution there. అక్కడ అవార్డ్ పాస్ చేసి ఇక్కడ మనం రికగ్నైజ్ చేయలేదు అనుకోండి, here you can go for execution. You know, it's a deemed decree, right? So first requirement of an arbitration agreement is it should be in writing. It should be in writing. There is no implied understanding. Contracts, you know, two different types of contracts. Express contracts, oral or implied contracts. Here there is no implied, only it should be in writing. It should be in writing, right? Next one, it deals with existing disputes or future disputes. Arbitration agreement can be entered into existing disputes or future disputes. Next, these disputes arise in respect of a defined legal relationship. This should come out of legal relationships, right? That means they are submitting their contractual obligation. Arbitration agreement eppone writing la irukono. Second one enna ippere disputes ado future disputes also it can be arbitrable. Next, disputes arise in respect of a defined legal relationship, whether contractual or not, right? The subject matter of the dispute is capable of settled by arbitration. That means certain disputes cannot go before the arbitration. కొన్ని disputes వచ్చి arbitration కి పోకూడదు. For example, criminal offences, fraud, ఇవన్నీ కూడా we should not go before the arbitration, right? So whenever you are entering into the arbitration, the subject should be capable of arbitrable, right? Now we are having first act is Arbitration Act 1940. ஏதாவது போயிட்டு இருக்கா மைண்ட்ல? Simply you are coming. You don't have books. You don't have books. You don't have pens. Simply you sit. You stare at me. Yes. When I asked one girl, I will catch hold you in Viva. She says, sir, I will see your eyes. I will see your eyes. You will send me out. Right? உன் கண்ணில் பார்க்குறேன் நான், நீங்க என்ன வெளில அனுப்பிச்சுடுங்க சார். சரி, you see my eyes. Right? No, different personalities will be there. So lawyer has to deal with so many people. So many people. என் கண்ணில் பார்த்தா பாருங்க பரவாயில்ல, ஜட்ஜு கண்ணெல்லாம் பார்க்காதுங்க ஸ்ட்ரைட்டா. Don't stare at the judge's eyes. You know, there is a, no, they will throw your case. Junior civil judges, all young judges will be there. Young judges will be there. If you stare at that eyes, then if you see any judge, anything more than 30 seconds, it's an offense. Terima. If you see a woman or girl for more than 30 seconds, if you stare at those people, it's an offense. Under IPC, judge nu kuda 30 నిమిషాలు ఇట్లా చూసిన సెకండ్ లోకే, then IPC will be invoked. You have to learn so many things. Right? Yes. నాకు తెలియకుండా నేను I practice at young stage. I stared at one judge. She's good. She's good. I saw. What's wrong? Yes. She thrown away and she went away. My case has been dismissed. Then I went to appeal. Dismissed in limine. No fact, nothing. Shit, go out. That's it. You have to learn so many aspects. Right? So, your place. Arbitration Agreement, Arbitration Act 1940 is there. It's the first statute, 1940 statute. It's defined as arbitration agreement as a written agreement to submit present or future differences to arbitration. Present or future differences. The Supreme Court of India, interpreting this definition, has held that this act does not stipulate any particular form. What the law required was an ascertainment that parties have agreed to go before the arbitration. Agreement only எந்த ஃபார்மலியும் தேவையில்லை. Just if by seeing that agreement, if it gives the intention that you are going for the arbitration, that itself is enough. Refer the dispute from the subject matter of the contract can be settled by the arbitration. Right? Section so and so provides that an arbitration agreement will satisfy the writing requirement. We can enter into different types of forms. There is no particular form of entering into the arbitration. We will see what are those forms. Arbitration agreement ku or prescribed document ledu. There is no prescribed format also. Right? We will see. It's a document signed by the parties. By a document, you can enter into arbitration agreement. Second one is an exchange of letters. ஒரு லெட்டர் போட்டு நம்ம ஆர்பிட்ரேஷன் போலான்னு சொன்னா கூட that letter can be treated as an arbitration agreement by exchange of letters, telegrams, other means of telecommunication which provide a record of the agreement. This is another mode of entering into an arbitration agreement. Now, you know, in a suit, plaint is filed. In an arbitration agreement, claim statement is filed. So, there is no arbitration agreement. Straight away, one party is going before the arbitrator, filing a claim statement. another party without denying, he is filing the defense statement. Then arbitration commences. For agreement kadiyadu, oka party velli arbitrator mundu em file chesado, claim statement file chesado, inkoka party dan dispute cheyakunda defense statement file chesadu anukondi, that itself implies that both the parties are at addendum to go into the arbitration. So first form is a document signed by the parties, an exchange of letters, telex, telegrams or other means of telecommunication which provide record of the agreement, exchange of statement of claim, arbitration law, statement of claim will be filed and in place of written statement, defense will be filed, which an existence of arbitration agreed is alleged by one party and not denied by the other party. Reference to a document containing an arbitration clause provided that contract is in writing and reference is such as to make the clause a part of the contract. Right. Now, two different forms of arbitration agreement is there. We will see. One is arbitration clause. Second one is submission agreement. Right? One is arbitration clause. Arbitration clause is entered even before the dispute. Submission clause is entered after the dispute has arisen. So, Arbitration Conciliation Act, which is based on UN Citral Model Law, conceptualized two basic types of arbitration agreement. First one is arbitration clause. By entering into the contract, both the parties will accept. The dispute will go before the arbitration. That is arbitration clause. Now we entered into the contract. Then dispute have arisen. After the dispute arose, then you are entering into the arbitration agreement. First case lenmo orala vanda polam. Second case la vanda uttu ipo nam arbitration porom. That is known as submission clause. So one is two basic types of arbitration agreement: arbitration clause and submission agreement. The arbitral clause is a clause which is part of the main agreement of the contract and refers to selection of resolution of all any dispute arising from the contract in future reference to arbitration. Next one, this is again, this is popularly known as, submission clause is known as midnight clause. Midnight clause. After the dispute has arisen, you are going into this arbitration clause. The other type of arbitration agreement is a submission agreement. It is a separate agreement generally entered upon when the dispute has actually aroused. It is much more detailed and specific about the choices that the parties make. It is also known as compromise agreement. It is also known as compromise agreements. One is arbitration clause. Second one is submission agreement. First, you have entering into that agreement even before the dispute has arisen. Second is after the dispute has arisen, you are going and entering into these agreements. Next one is valid requirement of an enforceable arbitration agreement under Arbitration Conciliation Act 1996. Requirement of enforceable arbitration agreements. Yes. Disputes over enforceability of an arbitration agreement can take a variety of forms. Existence, validity and scope of the arbitration agreement. They can also arise in different procedural settings including both arbitral proceedings and national courts. That means national court means the court which is having the jurisdiction over the arbitrator. And the national courts, for example, Supreme Court is there. It's a national court. Other within the Supreme Court of America, they are known as national courts. So whenever you are entering into the agreement, there are certain enforceability requirements will be there as existence, validity and scope and of the arbitration agreement. Right. First one is legal requirements for entering a valid contract under applicable law. Agreement refers to all or certain disputes arising from the contract which may arise between the parties in future. Next one, existence of a defined legal relationship between parties, whether contractual or not, and subject matter capable of arbitration, and agreement has to be in writing. Now, this is the case law in which Supreme Court has laid certain essential elements of an arbitration agreement. వేణుగా మన నిద్రపోతా అన్నాడు. నువ్వు వాడు చూస్తాను అనుకుంటాను, నీకు నిద్ర వస్తాను నీకు. మళ్ళీ పడుకోవచ్చు నిదానంగా కోర్స్ అయిన తర్వాత. Once you complete the course, once you complete the course, you can sleep. Right. We will see the elements of the arbitration agreement. No, you are senior, so many people fail in area. Don't think that you can write something. You know why? The main thing is, your paper is only for 1.5 hours. First aspect. Second aspect, you cannot fill 32 pages. Time irukadu. 32 pages idina 32 mark pass. Inga 32 page எழுத முடியாது. 1.5 hour தான் paper இருக்கும். At the most, if you write 15 to 20 pages, at the most, yes, 1.5 hour paper, you have to write 4 questions out of 5. So, you are hardly fulfilling your booklet. So, chances of getting over is difficult for you. So, within 1.5 hour, you have to write. Right. The Supreme Court has laid down certain requirements of arbitration. So first one is, there must be a present or future difference in connection with some contemplated affair. There must be present or future difference you can submit to arbitration. Intention of the parties to settle such difference by an agreement. The parties must agree in writing to be bound by the decision of such tribunal. The parties must be ad idem. That means free consent should be there for entering into these agreements. Next one is capacity of the parties to enter an arbitration agreement. If you remember again Indian Contract Act, capacity means the law says three. What are they? Major, sound mind, third one, not disqualified by law. Here, if you don't have capacity to enter into the main contract, and if you enter into the arbitration agreement, by virtue of that invalidity, this agreement also goes. Main agreement lo mana capacity kadiyadu. Ang illadappa ni arbitration agreement enter aane nenchuko. Our agreement not enforceable. That's what capacity of the parties to enter an arbitration agreement. Parties to the arbitration agreement must have legal capacity to enter into a valid contract under the law applicable to them. If an arbitration agreement is entered into by a party who does not have the capacity to do, according to New York Convention, the arbitration agreement will not be enforced on the basis that agreement is void, inoperative, incapable of being performed. So again, this is somewhat governed by the Contract Act. If you want to enter into an arbitration agreement, all the essential conditions of section 10 have to be satisfied in the arbitration agreement also, right? These are the requirements with respect to requirements of arbitration agreement, right? Got something today? Tomorrow we are going to see appointment of arbitrators. Slowly we are going into conciliation, different forms within 10-15 classes. I will complete, right? ఎక్కడ చేయాలి అది? క్లోజ్ చేస్తావా? ఓకే ఓకే ఎజెక్ట్ చేస్తావా? థ్యాంక్ యూ. Our treatment is based on the Daniel. Daniel treatment is based on the dependent.
Please settle down. Good morning, everyone. Please settle down first. Those who are standing outside, please come in. Now we will look how to draft a plane. Plain written statements and a quick different types of interlocutory applications. Please remain silent, please don't disturb others. Just bear with me for 45 minutes. Now, planes in Anna, what is a plane? It is a pleadings on behalf, filed on behalf of the plaintiff. The plaintiff approaches the court by way of pleader as per rule, order 3 of rule 4 of CPC. Clear with that, right? Now, if you wanted to institute a claim, as we have discussed earlier, we look as a lawyer, we should be knowing the peculiar jurisdiction, territorial jurisdiction, draft panna pora munnadi, few things you have to keep in mind. First thing, before which court you are gonna file it. Second thing, what kind of suit it is, whether it is money suit. At the back, please remain silent. If you have, for example, எப்பவுமே நமக்கு டக்குனு relief கிடைக்கணும் இல்ல. Especially in a civil procedure, it takes days or years for it to be completed, right? So, temporarily, what relief you are seeking for. Along with the claim, you can ask for supplementary proceedings. What are different types of supplementary proceedings? Could you please explain? Not explain, just name it. Arrest and detention of a person, attachment of a property, temporary injunction, appointment of a receiver, then any other type of interlocutory applications or interim reliefs that you can seek for. Clear? Say for example, if we have money suit, and the money is around 50 lakh rupees. Now 50 lakh rupees now the jurisdiction first you have to assign the jurisdiction which you are going to file. Which court you are going to file. So which court it would be? Sub-court, not district court, it is the sub-court. If it is below 10 lakhs, I think it is judicial sub-junior court. Rather than above 10 lakhs, it is the sub-court. Next, the 50 lakh rupees we have an apprehension that that person would evade justice. That is why he might flee from justice, abscond or whatever property he has in his hand, he might transfer, transfer. So if it is only in his name, he can claim it, right? He can claim the property out of his pocket, right? So our property transfer justice we have other remedies, immediate remedies that we can see before a court of law. By way of filing arrest and attachment. We can arrest that person and produce the person before the court, and the court will ask him to call his security. Why he shouldn't be arrested, and the court can ask you to pay the security, then he can be released. Secondly, by way of attachment. Order 38, Rule 5. says about when a person is trying to abscond or is trying to alienate the property or is trying to defraud the creditors. In all these circumstances also, you can file an attachment petition. Our property namakku attach pannalam. And all these attachment ஒரு attachment petition file பண்ணும்போது the court will never grant you the attachment directly. Always in an attachment, it will be a conditional order. Conditional order would be what? That when you are called upon, you have to furnish the security amount. Or else, show cause why the security amount should not be furnished. If he doesn't furnish the security or doesn't show sufficient cause, then the property can be attached. Only then the property will be attached. It is clearly mentioned in Order 38 Rule 5. Then, in temporary injunction, what are the scenario you can find temporary injunction? If there is wastage of property or rights of a person is being increased. In all these circumstances, under Order 39, you can find injunction. That means nama property kulla he is trespassing into the property as a matter of right. He says enakku easement rights irukku adanal unga property illa varum. But actually, if the property belongs only to you, then you can file an injunction, temporary injunction. That is, for the time being, he will be restrained from entering into my property. Or else, if a person is building a boundary wall கட்டிட்டே இருக்கும்போது நம்ம property உள்ளாவே ஏத்தி கட்டுறாரு. So, I can file a temporary injunction. Finality will be taking many years. So, temporary, I can file an injunction stating that for the time being, you should not go ahead with this construction. Okay. So, and if a property, there is a partition நம்ம suit file பண்ண போறோம், and there is a dispute among the members. Now, the rents and profits out of the property, parties kulle பிரச்சனை இருக்குன்னா, we can seek the help of a receiver to maintain the property, to distribute the sums among the parties. So, likewise, you have n number of supplementary proceedings other than the plainly கேட்கிற relief தவிர்த்து நமக்கு வேறையும் relief கேட்க முடியும். Clear? Now we are so நம்ம claim file பண்ணும்போது it is not that the plainல கிடைக்கிற relief மட்டுமே கிடையாது. You can seek for extra supplementary proceedings as well. But நம்ம எப்பவுமே claims draft பண்ணும்போது you should keep in mind order 1 as well as order 2. Order 1 என்ன சொல்லுது? Parties to a suit. It is mandatory when you join the party. ஒரு party நம்ம suitல join பண்ணோம்னா there are two parties, necessary parties as well as proper party. Necessary parties oda absence la namakku proper judgment kedaikadu. For example, if myself and Rohit is a party to a suit, he is actually the person who has borrowed money from me. அது பதிலா அவரோட father அவரோட sister நான் plead பண்ணிட்டு எனக்கு relief கிடைக்காது, right? So always the necessary parties has to be joined. If especially order 1 rule 9 la solludu, misjoinder of parties, especially a necessary party, would defeat the suit that we have filed. Some suit filed, but we would not get a relief. Likewise, when you join the cause of action, order 2 rule 4, I guess. Order 2 rule 4 la நம்ம causes of actions நம்ம join பண்ணும்போது same nature of cause of action ஆ இருக்கணும். If I'm asking the relief of getting money, அது கூட சேர்த்து நான் இன்னொரு relief attachment இன்னொரு relief totally different from the subject matter or the character of the parties shouldn't be clubbed together. Always joinder of parties as well as joinder of cause of action is important. Who you are going to include? What are the causes of action you are going to join together? Those two things are very important. Then, you know about representative suit, right? Order 1, rule 8. Representative suit is where there is one party against whom there are any number of parties seeking for the same remedy, but in different kinds. ஒரு maybe ஒரு சிட்டி ஃபண்ட் இருக்கு, அந்த சிட்டி ஃபண்ட் நம்ம ஏமாத்திட்டு போறாங்க. So what is the relief that the persons who have deposited money in that chitti fund to get the money? But the cause of action might have arisen in different times. Cause of action might have arisen in different times, but against one person. So, when one person, he can represent on behalf of all the other persons and sue. It is called representative suit. And if a representative suit prakaram ஒரு decision வந்துருச்சுன்னா, it is binding on all other persons. That we have already discussed in res judicata. Res judicata is also applied in representative suits as well. Now, moving on to the framing of suit, order 2 is very important. Namma ஒரு suit frame பண்ணும்போது, we should seek what all claims you want in one suit itself, so that repetition or multiplicity of suit can be avoided. இப்ப நம்ம ஒருத்தருக்கு எதிரா நம்ம ஒரு suit file பண்றோம்னா, I will ask the principal amount in one case, interest amount in another case, attachment in another case, which will lead to multiplicity of suits, right? நிறைய கோர்ட்டுக்கும் நம்ம what is it takes delay and time. So whatever claim you wanted to ask against a person, against a single cause of action in one particular character, then you have to ask in that particular case itself unless and until if the court is satisfied. If ஏதாவது ஒரு விஷயம் அதுக்கு அப்புறம் தான் நமக்கு தெரிய வந்தனா, we can by way of amendment we can include the same. Other than that, you are not supposed to. In the sub court, what happens? The court fees would be higher. So அதெல்லாம் இதே பண்றதுக்காக நம்ம ஏதாவது portion amount if you are relinquishing. Once you have relinquished one of the claim, that claim cannot be sought later in another suit. இப்ப நீங்க relinquish பண்ணிட்டீங்கன்னா, it is done and dusted. You cannot seek that same remedy again in another suit. Okay, so whatever you wanted to ask, you have to ask in that particular case itself. That has been mentioned under order 1, or sorry, order 2, rule 1. Then you have to so you, as an advocate, if a client you have all these things have to be there in your mind. Like blank out all these things should be there. These are all the basic things. Then, why do you institute a suit? It is by way of presentation of a claim. And while you present a claim, it should always be coupled with and it should be filed with duplicates. If you don't file with duplicates, it will be rejected. Now, as per rule 6, pleadings includes as a written statement as well as not as well as pleadings or plain or written statement. Now, written statement or pleadings, it has to be name of the court has to be there. That what is the case type, then parties and the small cause title and the pleadings. Parties are doing this. Then pleadings always the particulars of the pleadings have to be in paragraph and it has to be numbered and it should be called in sequence. Should be cohesive with one another, right? ஒரு fact சொல்லிட்டு அது உல்டாவா வேற fact, contradicting fact should not be mentioned in the plaint, because once you submit a plaint, it is an admitted fact, right? So admitted fact cannot be retracted, that we have learned already in the evidence science. So நம்ம fact நம்ம ஒத்துக்கிட்டு, because at the end of the plaint we are stating our verification. That is the importance of verification. That whatever matter is stated there is up to my knowledge, up to my belief and information, I am stating the same. So, adula namakku contradicting a statement kudakudadu. It should be always paragraph, it should be number, and whatever details that you mention must be clear and precise. You need not state evidence in the plaint as well. Now, if you depend upon any particular material like documents, that copy of the documents should be filed in a list format, and the list of the documents documents has to be mentioned there in the plaint, and it should be signed by the defendant as of the parties and an affidavit. Affidavit means what? It's a sworn statement. It's upon an oath the other person says the structure of a plaint will be. Same goes with the written statement as well. So here in the plaint, there is the name of the court, the court, then comes the OS number, whatever it is, the plaintiff and the defendant. You need not state the description right now itself. Just mention how many plaintiffs. If there are more than one plaintiff, plaintiff pair. Number 2, pair you need not mention the description while you state in the beginning. Then you have to give a small cause title, which is under which section or under which order of the law you are filing the whatever petition it is. Plain file under section 26, order 7, rule 9, 1 of CPC for realization of money. Then only you have to write the full description. Full description means the name of the person, the age, son or daughter of whom, and the address. Particulars, all the particulars. And after that, you have to write the statement. All services, notices to the plaintiff shall be served in the above said address or the counsel concerned. Same goes with the defendant as well. Then you have to go to the body of the plaintiff. The plaintiff humbly submits as follows. Now, what is the relationship between how you have entered into the contract? Say, for example, if it is a partition suit, or if it is you are challenging the will of the thing. For that, the opposite parties, the relationship had to be mentioned. Whether he is a father, regular siblings, so we are siblings, appa will pragar challenge all those things, all whatever you are contending for. It depends upon your creativity, the way you are, style and writing, you can develop on it. Then comes all the paragraphs must be numbered, and finally then comes cause of action. Either you can state the cause of action in a separate heading, or along with the pleading, you can number the same and write the cause of action. Cause of action is mandatory. Cause of action, number panni, dates reason, and you have to stay within the jurisdiction of the court. That is making sure that I have filed into the current jurisdiction. It shall not be returned. So, this is whether it is within this jurisdiction or not. Clear? Then comes the relief. What all relief you are seeking for? Whether it is of money, whether it is injunction, whether it is attachment, whether it is partition or possession of separate possession, or compensation, or specific performance of contract, rescission of a contract. In the type, whatever the relief that you are seeking for has to be mentioned. Relief that also had to be asked then and there. Next in your suit file relief whatever relief that you are seeking for, especially in a declaratory decrees. Declaratory decrees suit file whatever alternative relief that you are seeking for must also be mentioned. And finally, the valuation. That is suit value the property, property value or property value. And if it is a mobile property, the mobile property, mobile property, you are asking for recovery of mobile property. Along with that, you have to mention the, as a certain sum of money equivalent to the mobile property. So, for example, I have a car that persistent cake, you have to give me at least the money worth of the equivalent to that property. Clear? If it is damages, you are seeking for compensation. If it is like defamation, or a certain sum of money had to be asked. Then, very important thing, if you are seeking a remedy with regard to an immovable property, then you have to mention the schedule of the immovable property. Why? What is the necessity of mentioning the schedule? to identify the property. In order to identify the property, you have to mention the schedule as well. So since it is an identification, much info is not given, then other I will show you. Then comes the verification. So if the immovable property, it always should be in a tabular format. Likewise, the district, sub-district, taluka, village, corporation, all those things. Extent, important. If we attach panna porona, if 5 cents of property, that what is it? Extent of the property. Then you have to write the boundaries of the property. Important. Boundaries of the property. North, east, west, south, என்னெல்லாம் property adjacent. Only then you can identify the property and the description of the property. What kind of property it is? For hilly area property, a paddy field, the nature and the lie of the property. All those things has to be mentioned, so that if you appoint a commissioner, the commissioner should be able to understand and locate the property, the nature and lie of the property. Innother property la poi nama attach panna mudiyadilla. So in order to identify the property, detailed description of a property has to be mentioned. If it is immovable property. If it is movable property, movable property you can ask for a value equivalent to the worth of the immovable property. Clear? If it is you are seeking for any kind of compensation, you can ask for the what money value, like compensation you can seek pandringla. I am seeking a compensation of rupees 20 lakhs. So that has to be mentioned. Then comes the verification, then all facts stated above are true to the best of my knowledge, belief and information. Then comes the list of documents. List of documents starting from legal notice is important. Legal notice, if there is any reply notice, if there is any documents that you rely on, suppose if it is a copy தான் நம்மகிட்ட இருக்குன்னா attested copy number for the time being you can produce it, but at the time of trial you have to produce the original or the certified copy. If it is the evidence act section 65 படிச்ச மாதிரி whatever scenario you can find certified copy அது எல்லாம் file பண்ணலாம், or secondary evidence of such copies can be filed. And this claim shall be accompanied by an affidavit. An affidavit, short affidavit the case, I am the plaintiff of the case, I know the facts of the case, and whatever details has been furnished is true. It's holding that whatever is mentioned in the claim is true. And then the affidavit is always signed by a defendant. One party of the plaintiff, number of parties, one party need to sign the affidavit is enough on behalf of everybody, and it will be signed by the attested by the advocate. That is the in short how you have to draft a plaint. Then goes written statement. Written statement na same da. It should be numbered. It should be in paragraph, and you shall not state any defense. Your denial shouldn't be evasive. It should be very, if you are pleading anything particularly, those particular facts have to be mentioned. In the written statement, you need not write the full description of the persons, because it is already there in the plea. You just need to mention one parties. Plaintiffs 1, 2, 3. Even sometimes we can write there are more than one plaintiffs. Danya and another. One person and another they can write. Goes to the same under defendants also. Then first item. Written statement filed under Order 8, Rule 1 of CPs. As you can see here, it's already been numbered. It's in paragraph and it's a number. Why we are numbering? As we have stated earlier, it is for particularly you have to deny the fact, or particular if you wanted to admit a particular fact. At least if you can't remain silent, please pay act as if you are paying attention at the back. உங்களால கவனிக்க முடியலன்னா கவனிக்கிற மாதிரி நடிக்கவா செய்யுங்க ப்ளீஸ். So what would be the remedy that the defendant is seeking for? To dismiss the petition, to dismiss the claim at the cost of the plaintiff. The number you have to find it out and sign, put the signature of the defendant. Now, interlocutory application. Interlocutory application, number padichom. Under section 94, there are different, and under there are particular interlocutory application, particular orders. Now, if you are filing an attachment, what you have to do? There should be a petition and there should be a attached affidavit. Clear? Petition and petition number order number what provision you are under what provision you are seeking it, you have to mention. That is before the honorable so and so in IA number so and so in OS number so and so the parties. Now I have told you in the previous classes how do you address a person who is filing the petition? Petitioner. Even if it is a response, even if the defendant is the one who is seeking the petition, filing the petition, he will be named as petitioner bar respondent, or the other person would be counter petitioner bar plaintiff. Understood? Or if the plaintiff is the one who is filing the petitioner, it will be petitioner bar plaintiff, counter petitioner, or the respondent bar defendant. Clear? That should be clear. What is it? Interchange agakuda. Then a petition filed under Order 38 Rule 5 of CPC. Then you have to write in a single paragraph only. What is it? And the petition soldier. All the kadayella in the affidavit that he is trying to alienate. He has borrowed a sum of rupees 10 lakhs from me, and he has made a default in the payment of money. Now I have filed along with this suit. I have filed along with this petition claims. I am filing this suit, seeking for attaching the property because I have gotten information he is trying to alienate the property to another person. So it will, if he does so, if attachment is not given, it will cause irreparable loss and injury to me. So all these facts have to be mentioned in the affidavit only. Now in the petition, you need to mention only in one paragraph that the property had to be attached. Clear? So in brief, we have to mention what is the cost of which you are filing this petition. I think this is injunction petition. So, ஒன்றும் இல்ல நம்ம plaint எழுதுறோம்ல plaint எழுதும்போது நம்ம எப்படி எழுதுவோம் the plaintiff what is it the defendant borrows some of rupees so and so the plaintiff so and so அந்த plaintiff எல்லாம் மாத்திட்டு I ன்னு போட்டா போதும் I have given the defendant D1 sum of so and so அப்படிதான் நம்ம affidavit மாத்துறது main claims ல இருந்து affidavit மாத்தும்போது you instead of writing that plaintiff you have to write I have given him so and so instead of claim மாத்தி எழுதினா போதும் you need and in affidavit you need not mention the cost of action வேணும் valuation அது என்ன எழுத தேவையில்லை and this is how the petition would be. The name of the court, IA number, OS number, whatever it is, and the party. C. Plaintiff, petitioner, plaintiff. Please remain silent. And how defendants example around the defendant's name in detail and responded by defendants. Now only this paragraph is more than necessary. Let's petition filed on behalf of the petitioner or plaintiff under Order 39 Rule 1 and 2 read in Section 151 of CPC. That for the reason stated in the accompanying affidavit, it is prayed that humbly the court may release past and temporary injunction. Whatever remedy you are asking for. It is commissioner application, or attachment petition, or injunction, or whatever it is, only that has to be mentioned here. And the name and the, what does it say? Plaintiff petition order, advocate order signature. Affidavit will be signed by the defendant or the party. Petition would be signed by the advocate. Clear? Petition would be signed by the advocate. And the affidavit would be signed by the parties. And affidavit should be attested by the advocate also. That he has signed before me, my office. That has also been signed. Then, if it is with regard to any property, the schedule of the property must also be mentioned. No, that is the case where the advocate has to put the signature. Advocate for the claim. என்னோட client உங்களுக்காக தான் நான் petition file பண்றேன். So உங்களோட behalfல நான் sign போடுவேன். Affidavitல since you are sworn, நீங்க தான் oathல நீங்க sign பண்றதுனால it should be signed by you. I have to verify that you have signed in my presence. Whereas petitions being filed by the advocate. So advocate for petitioner of plaintiff means the person who is filing the interlocutory application and the number order advocate and the sign one. And this is how what you have to write the schedule. Schedule with regard to a movable property. You varlaya. That is district, sub-district, taluk, village, survey number and extent. It is mandatory. This thing is mandatory if you are seeking the remedy out of an immovable property. Clear? The schedule should be containing of district, sub-district, taluk, village or corporation, whatever it is. Then survey number, very important, and extent. Extent means the property. The property or sense acres, hours, generally we write in hours. And boundaries. Boundaries so that you can identify the property. That north was property belonging to so and so person. South whatever it is, in order to identify the property, the what is it? North, east, west, south, the boundaries and properties that has to be mentioned. Then your description spelling the property. The description of the property. And the description and the details and the nature of the property. What kind of property? Is it a building? Or is it a residential house? Or is it what commercial plot? Whatever it is, and the nature of the property, or it is an agricultural plot. And the nature of the property has to be mentioned, lying within the boundaries of so and so boundaries, with an extent of so and so sense. This has to be mentioned, and it shall be signed by an advocate. So that is with regard to now that is with regard to claims and registry. Now, extra remedy since we are talking about extra remedies other than interlocutory, actually a written statement is a defense, right? Defense sought by the defendant with regard to the arguments contained in the claim of money. Then you have to admit, say for example, if my allegation against is that he has borrowed 1 lakh rupees from me and he hasn't paid the amount. Now, the other person is admitting that I had borrowed, but I have borrowed earlier from 50,000. So I am only obliged to give him 50,000. Or you can totally deny it. So that is only happening in set-off. Set-off can happen only in a money suit. Whereas in counterclaim can also be treated as cross-suit. it has all the nature and like as if the separate suit file பண்றதுக்குள்ள remedies இருக்கு. ஆனால் what happens is this is a and the party should be all the same character also. And you are entitled to file counterclaim along with the written statement as per orders 8 rule 6. Now in a counterclaim, if the plaintiff counterclaim main original suit like the plaintiff is absent and the suit is being dismissed, this counterclaim can be transposed, can be treated as an original claim, and the other party would be set ex parte. That's all the students you know, right? Now, if you claim the file பண்ணிட்டோம், return statement file பண்ணிட்டோம். Now let us see the consequences wherein the suit has been dismissed or the party is being set ex parte. What are the consequences? Now what are the circumstances under which a suit can be dismissed? What all are the circumstances under which a suit is dismissed ஆகும்? It is dealt under order 9. There are 4 circumstances under which a suit can be dismissed. Under order 9, rule 2, rule 3, rule 5 and rule 8. What rule 2 says about? When the summons are not served, when the plaintiff is ought to serve the summons within 30 days, right? Now he hasn't taken any steps to give no summons to the other person, then the suit is said to be dismissed. Then when the either party appears, plaintiff who varala, defendant who varala, they are not appearing before the court, then also the suit would be dismissed. Then or plaintiff, the court has asked to take summons within 7 days. Now, the plaintiff is not taking steps within 7 days. In that scenario also, the plaintiff would be dismissed. Then, the defendant is appearing, the plaintiff is not appearing. So, in this 4 circumstances, a plaintiff would be dismissed. Now, what would be the consequence if the plaintiff is dismissed? And what is the remedy that is available to the plaintiff? He can restore the petition. He can restore the petition under order. He can restore if he shows the court the proper cause that why he couldn't appear. If there is any sufficient cause, the court can restore the petition. You can ask for restore the petition. Now, what if the defendant doesn't appear? What will happen? He would be set ex parte. In same scenario, ex parte order under order 9 rule 30, he can ex parte order the decree namukku set aside pannuvom. Set aside means keep aside the order that has been passed against the other person and you can get the relief under ex parte. Ex parte set aside pannalam. Now, I think I didn't mention. Or claim I file panren. Along with the claim, I have filed an attachment petition. Now this claim was dismissed. Attachment petition was ordered. The attachment authorized. Now I have filed the claim. That claim was dismissed because of the causes that have been mentioned. Either of the causes. Rule 2, 3, 5, 8 plus 1 eda cause at claim to dismiss ஆயிடுச்சு now. Would attachment also be dismissed? Attachment will also be dismissed when the plaintiff is being dismissed. Now, I have restored the petition. Now, plaintiff I restore petition. Now, if I restore, would the attachment that was also dismissed would be restored? It will not be restored. But in the case of execution, the court would give you the time, either give you direction that it shall be restored, or if the court gives you particular time period, only for that period it will be restored. Or else, if the court is not giving you any direction or time period, and number attached execution of attachment point. Now, suit number attachment panirona, that attachment need not be reattached in the execution also. You know about execution proceedings, right? When a decree is being passed. Now what is an execution? What's execution? What's execution? Execution simply means it's a realization or enforcement of any decree or order which can be enforceable. Not every order can be enforceable. It's not everyone, not certain. Appeal level, but whatever order the court has passed or whatever the decree the court has passed, and the any order or decree enforced பண்ற method தான் execution. Now while you are executing, now it's the decree holder. Decree holder is a person who files the execution petition in whose favor a decree has been passed or an order executable. ஒரு executable order pass பண்றவங்க தான் decree holder, and judgment debtor against whom a decree has been passed or an order capable of executing has been passed. Clear? Now in execution also, we have discussed earlier that there are two types of execution: oral application as well as written application. Oral application happens only in money suit when the judgment, when the court is pronouncing the decree with regard to a money decree and the judgment debtor is within the presence of the court, then and then you can execute by way of arresting that person. Clear? We will continue in the next class. Thank you guys. Please remain here, we will have a next class.
N number, no need. There is 15 numbers also mention 15 numbers. Cannot represented by one plaintiff, madam. So because of that you have to file in the application form. ఇంకా రాలేదు భరతి సార్ మోహన్ ఇదియా 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 ఇదే కదా ఇది పెట్టేద్దాం
క్లాస్ తర్వాత చెప్తా. ఓకే. శర్మ శర్మ లోపలికి రా. కలిపి కలిపి. Yes. We will continue. Let me start the session. శర్మ వచ్చి అక్కడే ఉండిపోతాం, లేకపోతే ఆక్యుపై యువర్ సీట్. కమ్ అండ్ ఆక్యుపై. నేను ఏది మాట్లాడలేదు మిగలేదు, ఏదో ఒకటి తగ్గి చేద్దాం. పెట్టుకుని కూడా బాగా. Last row. Yes. Today I will discuss how the relation between the bar and the bench is maintained. It's not audible. Now, వాళ్ళకి ఫోన్ చేయాలా? మింగేయా? The last row. Yes. Done. Yes. You are already late to the class. I felt few students who are occupied in 4th floor not able to get their doubts clarified. And so whenever time permits, you please meet your concerned faculty and get all your doubts clarified, because we will be here till 4. Okay? And those who are in auditorium, you have no objection. You can get your doubts clarified then and there. No photo, please. No. Note down the points. And what is a bar? What is a bench? First, you need to know whom we call as bar and whom we call a bench. Advocates are bar. The judges sitting in are bench. And so, in this, we will be seeing the role of both an advocate as well as a judge to establish, to maintain a cordial relationship between the two. So there lies a mutual obligation. The duty lies on both for speedy disposal of cases and to try the case without any bias and to give a pure justice. And in this, as I said, we will see what is the role of bar and what is the role of bench. All the duties mentioned here have been already discussed in different headings in our earlier classes. So you may feel like a repetition because these are all the general duties. The role of an advocate and role of a judge. Here, judge also has to be very cautious while dealing with client, advocate, and delivering judgments. Okay, and so let us start. Coming to the role of bar, first we will see the role of an advocate. Role of bar to establish the cordial relationship. Number one, you can note down the points if you want. Advocates should give due respect to the judges and must avoid speaking ill of the judges. Is this not a duty of a bar? Is it not a duty of an advocate? So what amounts, if an advocate speaks ill of a judge, ill of the proceedings, whatever it is, it leads to misconduct. It leads to professional misconduct. So when we do not obey the rule, do not observe this rule, then there the situation will be like thinning of relation between the bar and the bench. Judge may feel, again, next, an advocate should help a judge. An advocate should help the judge. Help in the sense, in what areas, at what time advocate's assistance is required to a judge to come to a conclusion, to come to a fair conclusion. Only if or only with the assistance of an advocate, with transparency, a judge can deliver fairly. And next, an act of advocate should not irritate the judge. An act of an advocate should not irritate the judge. Can you give an example for this? Speaking loudly. Okay. In an angry mood. Okay, with rough voice. You mean to say with rough voice? Okay. Delay. An advocate has a habit of repeating the facts, issues. Cheppide, cheptuntaru. He will not move further. Can that be considered as a situation where a judge gets irritated? There are. ఈ రోజు నుంచి మీరు అబ్జర్వ్ చేస్తూ ఉంటారు కోర్టులో కోర్ట్ విజిట్ ఉంది కాబట్టి ఓకే ఎస్ సో an advocate should not irritate the judge. If the judge's behavior is irritating, then what happens? Vice versa తీసుకుందాం. Advocate is bound not to irritate a judge. But if judge is or the act of a judge is such that an advocate gets irritated, then what is the remedy? Can an advocate enter into a direct conflict with the judge in the court hall? No. Advocate is not permitted to. Remain silent, and then that can be taken to the notice of the authority and can get the matter settled. Yes. Protocol in the sense? Yes, we have seen in our previous classes. Duties towards an advocate, to the court, duties towards the court. Okay, so there are rules, only according to them. If non-observance of those rules leads to misconduct. Okay. And next is, if the judge pronounces a wrong order. Situations like judge pronounces a wrong order. We are not bothered about what made the judge to pronounce such order. Situations, facts, ఏదో ఒకటి ఉంటుంది. So if a judge pronounces a wrong order, then what is the remedy that an advocate has? Only remedy is the aggrieved party can prepare an appeal. This is what you have studied in your sessions. Avna? So in such situation, can an advocate behave rudely against the judge or with the judge in the court hall or in public? No. So, these are all the situations where the situations arise, but one has to remind or one has to keep in mind that there must be some cordial relationship. ఊరికే రచ్చకు దిగకుండా ఆర్గ్యుమెంట్స్ దిగకుండా disputes or differences can be settled through proper intervention, not with direct agitation or arguments. Next comes the role of bench. What is the role of bench? What is the duty of a judge? Role of a judge to strengthen the relation between bar with bar. బార్ తో పాటు ఎట్లా రిలేషన్ ని మెయింటైన్ చేయాలి, కార్డియల్ రిలేషన్ ని మెయింటైన్ చేయాలి. ఇట్స్ నాట్ అబౌట్ గోయింగ్ టు అవుటింగ్ ఫ్రీక్వెంట్లీ, అది రిలేషన్ కాదు. ఓకే, వీకెండ్స్ వస్తే బయటకు వెళ్ళడం అది రిలేషన్ కాదు. దట్ ఈస్ నాట్ ఎ కార్డియల్ రిలేషన్, దట్ కెనాట్ బి కన్సిడర్డ్ హియర్. ఓకే, దట్ ఈస్ ఎ ప్రైవేట్ మ్యాటర్. అండ్ సో లెట్ us see what is the role of bench. An advocate, just like an advocate who has to follow certain rules and regulations to maintain the relationship, to establish the relationship, a judge too has to observe. So, what ultimately here is, judge is also responsible for cooperation, cordial relationship. Can a judge speak ill of an advocate in the court hall? Can a judge make a statement which deteriorates the status of an advocate? No. Judge is not allowed to. Because it is the duty of both bar and bench to maintain the dignity and decorum of the court. The rules. But what's happening recently in Calcutta, social media lo kuda vachindi kada. The judge is shouting at a junior advocate and made a statement. And used the word rubbish garbage of the court. You are the rubbish garbage of the court. Will it a fair statement? Is it a fair statement? No, it's not. So, మనం థియరీగా చదివేది ఒకటి, ప్రాక్టీస్ లో ఇంకొకటి జరుగుతూ ఉంది. సో టు వాట్ ఎక్స్టెంట్ they are observing, they have an idea of their jurisdiction. What can be uttered, what cannot be uttered must be known to everyone, be it an advocate or a judge. Okay. And next, judges should hear the case with open mind. When they are close with their own perceptions, their own presumptions and assumptions, they may not be able to deliver a fair judgment. They must hear, they should give an opportunity to an advocate to express all his views. He must be in a position to receive the things. Next, judges should act impartially. What do you mean by impartially? Unbiased. Biased kaadu, unbiased. Avuna? He should not show any favorism to a senior most advocate. He is the very senior most advocate. So whatever he pleads, whatever he drafts is true. And oka presumption tho velakudu. He must be very unbiased, impartial. And next, judges must avoid all sorts of interruptions. Interruptions while dealing or while an advocate is pleading. Arguments jarugutuna, chief aina, cross aina, judge has to give them some time. A judge should not interrupt in between. But there are situations where a judge is permitted to ask certain questions regarding the facts. Question of law. Okay, so there is not an absolute restriction on a judge. అసలు ఓపెన్ చేయకూడదు, మీరు ఇంటరప్ట్ అవ్వకూడదు, నేను ఆర్గ్యూ చేసేటప్పుడు చెప్పడానికి లేదు. A judge can in those situations. Next, when preference is given to old cases to dispose of, that is a very long pending case and so we have to dispose it of very quickly. అని ఒక టార్గెట్ పెట్టుకున్నారంటే now the judiciary is in such trend. They want to clear out the cases. వాళ్ళ కోర్టులో వాళ్ళ దగ్గర ఉండే కేసెస్ ని ఎంత తొందరగా కుదిరితే అంత తొందరగా డిస్పోజ్ చేయాలి. పెండింగ్ కేసెస్ ఏమి జీరో ఉండాలి. రీజన్స్ ఏమైనా ఉండొచ్చు, వాళ్ళ యొక్క ప్రమోషన్ అయినా ఉండొచ్చు, అదర్ రీజన్స్ అయినా ఉండొచ్చు, వాట్ ఎవర్ ఇట్ ఇస్. సో when they are in a trend to dispose of the old cases, old pending cases quickly, they should be very cautious while dealing with the fresh cases. They should note that even the fresh cases has to be tried on par with the old cases. Otherwise what happens? The fresh cases mali idi pending lo untundi. Fresh case pending lo untundi. Old cases clear avutu unde koddi fresh cases pending lo untundi. So he can opt to decide. Next. Cases shall not be adjourned without reasonable ground and sufficient grounds. What do you mean by this? What do you mean by this? cases cannot be adjourned. Cannot be. Why that is true? There are judges who are known for, just like an advocate who seeks adjournments. Next అడిగే వాళ్ళు judges కూడా ఉన్నారు. So it is their duty not to adjourn the cases. So for speedy disposal of cases, you should not apply this rule. A judge should not apply this condition. వాళ్ళ యొక్క రిటైర్మెంట్, వాళ్ళ యొక్క సర్వీస్ డేట్ దగ్గరలో ఉంది. What generally they do, there are judges who dispose of before their retirement, but there are judges who adjourns so that the next judge will take care of it. మనకెందుకు తలకాయ నెక్స్ట్ వచ్చే వాళ్ళు చూసుకుంటారులే. That should not be the tendency of bench. Okay. And next, judges should not make unwarranted comments. This is what I told you. Unwarranted comments in the court hall. He should not make unwarranted. Unwarranted అంటే ఏంటి? అనవసరంగా ఉండేది, అవసరం లేనిది, which is not relevant at that moment. Because it is the duty of the bench to preserve the dignity of an advocate also. Due respect must be given to an advocate, be it a senior or a junior or a fresher. There are judges who encourage the pressure. They give them time to plead. Even when they are in a hurry and getting tense, they just cool the situation. That should be the attitude of the bench also. Okay? There are. And next, judges should possess deep knowledge of law and should have the ability to apply the proper law to the disputed facts to take a right decision, to come to a right conclusion. When a judge is not aware of the law, state laws, then this happens when a judge belongs to another state is transferred to another state. This happens. So state legislations, the judge must be aware of the state legislations, the amendments which have been made to the state legislations, state acts, etc., etc. And next, the judges have the primary responsibility to protect and preserve the independence of judiciary. Hence, they should not yield to the pressure of the government. Can you explain this? A political motive ఉండదు.
Already ruled for having powers, but entirely ruled separate, administration separate by elected people. And government having more authority, it is not dominated by the law. Law is right decision to take the good portion. Basically, I mean,
There are situations you might have read in newspapers also. E judge, E party related. So and so judge, he is supportive of so and so political party. So whatever the complaint, whatever the case approaches the judge against this, that will be settled in favor of the government. Avana? Unnaya leda? Is it not amount to misconduct? Professional, is it not amount to losing the dignity of the judicial system? Yes or no? Yes. It's happening. Then who is the authority? How to control it? Any solution to that? No. Huh? ఏం చేయలేదు. ఆ జడ్జి ఆయన సర్వీస్ లో ఉన్నంత వరకు వీళ్ళు సేఫ్. ఈ పొలిటికల్ పార్టీ ఈజ్ సేఫ్ బికాస్ he is holding a position. ఆయన దిగిన తర్వాత వీళ్ళకు ఉంటుంది. Okay. Next, a judge should be honest and morally right. A judge must be honest. The same is expected from an advocate also, and so from judge too. At regular intervals, meetings of judges, meeting between judges and advocates must be established. Meetings must be conducted to see that the differences are settled, the differences between bar and bench are settled amicably. The second half of the auditorium, mind you, second half and next comes the Contempt of Court Act. What do you mean by contempt? Contempt. What do you mean by contempt? Against the court. Court proceedings. Against the court proceedings. Non-compliance. Disobedience. Misbehavior. Not following the rule. Intentionally or unintentionally. Either way. Okay. Mostly intentional. Criticism. Criticizing judge or a judgment. Okay, legal fraternity. Mottam. Next. Part C important. Last rows. So, Contempt of Court Act. In which year it was passed? 1971. After going through the legislation, you just think whether you require any change, any amendment to this legislation. Kavalna. Change undalna. Do we really need an amendment in the provision of Contempt of Court Act? Yes. So, the main object of passing this legislation, Contempt of Court Act, is, what is that? To protect the dignity and decorum of. Dignity and decorum. What do you mean by dignity? What is decorum? Upliftment of justice system. Dignity and decorum, and to uphold the majesty of law, the supremacy of law. Showing due regard to the justice system, the judiciary. It doesn't mean that the judges are protected against any source of criticism. If it is a fair criticism, then that doesn't amount to contempt. Doesn't amount to contempt. Court dikkarana antuntara vinnara vinnar. Tamil enna solluvaanga? Fair criticism. It's not fair contempt. Fair criticism. If it is fair. I am not talking about fair criticism. I am asking what contempt of court is. Contempt in Tamil. Say. Thank you. And so, let us see the definition part of contempt. what amounts to contempt, what is not contempt, what is brought under the definition of contempt. What does it mean actually? We do not find an exhaustive definition, a clear definition. That do not define it clearly. The definition is not exhaustive. And so, what happens? Depending on the situation can be considered it as contempt or not amounting to contempt. The last words. And so, contempt can be a willful disobedience to the order of the court. Non-compliance can be a non-compliance of order. These are all amounting to contempt, which amounts to contempt. Okay. Any disrespect to the authority, disobedience to the order of the court, and the third one is disturbance to the proceedings of the court. An advocate keeps on disturbing the judge while making orders, while passing orders, can be considered as contempt of court. Yes, can be considered as contempt of court. And this contempt is of two types. One is civil and the other is criminal. Civil contempt and criminal contempt. What is civil contempt? What amounts to criminal contempt? ఇది మీరు తెలుసుకోవాలి. Civil contempt. Coming to civil contempt. You are not supposed to take photos. Please note down. Don't be lazy. So what is civil contempt? What amounts to civil contempt? So it is a willful disobedience to an order, a judgment, a decree. Order ante adi em order aina undachu. Even it can be an interim also. Yes or no? Yes. The other process of the court or willful breach of an undertaking given to a court. Willful disobedience. In simple, we call it as willful disobedience to the order of the court. That's all. That is civil contempt. Coming to a criminal contempt. కొంచెం హైగా ఉంటుంది contempt. Nature of contempt is bit high. Publication of any matter by words spoken or written or by signs or by visible representation, it's not visual representation, visible representation, or doing of any act, any other act, which scandalizes, or tends to scandalize, or tends to lower the dignity of the bench, the judge, and the act is prejudicial to the judicial system. An act of advocate is prejudicial to the judicial system, whatever it is, the judiciary. And if an advocate interferes or obstructs any proceedings in between, then that amounts to criminal contempt. Very good. We have a definition of civil contempt and criminal contempt. But what is the punishment for contempt? What is the punishment for contempt of court? Is the punishment different or same? It is the same punishment provided under Contempt of Courts Act. Civil contempt ko okay punishment hai, criminal contempt ko okay punishment hai. What do you say? Nature differs. And so punishment should also. Avuna? But we don't find a different kind of punishment. The punishment is same. Punishment is same for both, be it a civil contempt or criminal contempt. The punishment is this. What is the punishment? Simple imprisonment, SI. Superintendent of కాదు. The other word కాదు. Sub inspector అసలుకే కాదు ఇక్కడ. Okay. Simple imprisonment for a term which may extend to 6 months. Which may extend to 6 months. Or fine which may extend to 2,000. Or both. Simple imprisonment and fine. Neither the punishment is different for civil and criminal, nor the punishment given for the contempt is sufficient. Avuna? 1971 లో ఈ పనిష్మెంట్ అనేది ఇచ్చారు. But when the contempt proceedings are increasing day by day, the punishment should also change. This is what I feel. Personally, I feel. Is the amount mentioned 2,000 rupees fine? Is it a proper fine? Is it sufficient fine? That's what I'm saying. At the time of enactment, 1971 లో 2,000 rupees fine అనేది, that was a huge amount. Huh? That is the highest amount. Why should not be a change in the punishment? This is what my question is. ఎందుకు? Because of seniority. Because of seniority. That's what. A senior advocate. Huh? I agree with you. I agree with you. We have to take into consideration the person, the character of a person, etc., etc., etc. But what you are saying is character of a person, the personality has to be taken care. While applying a penal provision. This is what you mean, right? Whether the same rule is applicable, the same perception is applicable even for the other offences? Why not? I'm not talking about this imprisonment. I'm talking about the penalty, monetary penalty. If it ends there, okay. If an advocate is habituated to such contempts and all, dismissal from bar. So, Yes. Yes. So what you feel is the punishment must be different to civil contempt and criminal contempt. That's what he told. That's what. My question here is, should the punishment is same for civil and criminal, or do we need a change in the punishment? Criminal contempt kuda em Sharma? I understand, ma. I understand what you are saying, but when there is a different nature of contempt, civil contempt and criminal contempt, అసలు కామన్ గా ఉంటే అసలు డిఫరెన్సియేషన్ ఎందుకు అవసరం లేదు. ఓకే, క్రిమినల్ కంటెంప్ట్ ని తనిగా పెట్టిన తర్వాత ఇప్పుడు చూసినామని అంటే కొంచెం హయ్యర్ రేట్ లోనే డిసోబీడియన్స్ అనేది ఉంటుంది. సో ఇన్ సచ్ సిచ్యువేషన్ penal provision is same, or do we need change? This is what my question. I 100% agree that a personality has to be recognized. We should give due respect. ₹1 fine అనేది just for నామకే వాస్తే అది పెనాలిటీ నే, వాళ్ళ యొక్క నేమ్ ని చార్జ్ చేయడానికి కోసమే. ఓకే, ఐ అగ్రీ. బట్ క్రిమినల్ కంటెంప్ట్ అని వచ్చేటప్పటికి when the contempt is bit more, they should have drafted in such a way that for criminal contempt ₹1,000 fine, for criminal contempt 2,000 fine. అందుకే క్రిమినల్ కంటెంప్ట్ కి 2,000 పెట్టి సివిల్ కంటెంప్ట్ కి 1,000 పెట్టి ఉండొచ్చినాయి, లేదా ₹100 పెట్టి ఉండొచ్చినాయి. నీ ప్రకారం ఎందుకు అక్కడ కామన్ గా పెట్టారనేది నా క్వశ్చన్. Coming to the differences. Yes, the differences available for civil contempt and criminal contempt. If an advocate is charged with a contempt, he takes recourse to any one of the suitable defenses available to him. Any one of the suitable defenses. Can you name one defense? Defense. General defenses. Not intentional. It's not willful disobedience. Not intentional అంటే చెప్తే సరిపోతుందా? Situations warranted the advocate to act in such a way. Very good. You have a valid defense. Next. To apologize. What? That's not a defense. Defense is what? What do you mean by defense? You have been charged with a contempt, and you say that no, my act do not amount to contempt, and you make a reason. Huh? Sharma don't represent others, okay? Let him express what he feels. Huh? Acting in good faith. Whenever court does beyond its power, court acted beyond its power. Ah. Who will pass this order? Contempt order. Ah. Got it. Got it. Exercise excess jurisdiction. And so, court does not have jurisdiction to pass the order. Advocate need not obey the order. This is what you feel. Yes, that is the difference. That is the difference. Hmm. Depends on one's own interpretation. Yes. You just note down the differences here, note down the important differences here. We will have a discussion on this. The last pages. We'll give you a minute time to note down and then I'll shut down. I'll close the slide. We'll have a discussion on this tomorrow. The differences. Difference. Na action ki dani padi.
We will discuss. కొందరు అడ్వకేట్స్ ఉన్నారు. కొందరు అడ్వకేట్స్ ఉన్నారు. కావాలని నాకు తెలియదు. నాకు రాలేదు. నాకు ఆర్డర్ నా చేతికి రాలేదు. నాకు తెలియదు ఆర్డర్ వచ్చినట్టు. కానీ విని ఉంటాడు. ఆర్డర్ వచ్చేసిందని విని ఉంటాడు. కావాలని తీసుకుని దాన్ని కూడా హెసిటేట్ చేసి ఉంటారు. అవాయిడ్ చేస్తూ ఉంటారు. ప్రభుత్వం ఉన్నారు. అయిందా?
Last class we have discussed about what is crime and all that things, how the statistics help to control the crime. Today we are going to discuss about the reporting of crime. In CRPC, when we discuss in CRPC, mostly CRPC is divided in three parts. If you closely study that thing, CRPC is mostly divided into three parts. First part says about the investigation, second part says about the inquiry, last part is about the trial. Yes or no? So, while investigation, that means a criminal proceeding is started, first initial stage is the investigation. But question is how that investigation is started. By reporting a crime to the police officer or something. How that can be happened? It can be happened in these four ways. One, by visiting to the police station. Second, by telephone to the police station. Third, by reporting to the nearest magistrate. Last one, by an online FIR. So,
First one, by visiting to the police station. Mostly, this provision means by lodging an affair in the police station. What do you mean by affair? I don't ask the full form of affair. I'm just asking what is affair. Okay, first tell me where the affair is defined in CRPC, which provision is defined, which provision of CRPC defines the word FIR, for first information report. Sorry? Can you confirm that section 154 defined FIR? Actually, the definition of FIR is not there in the CRPC. But yes, section 154 deals with the provision of FIR. Where to give the FIR? For what kind of offense you have to give the FIR? All that provisions are given under section 154, but definition of FIR is not given in the CRPC. That's the one. Deals in under section 154. But it is not defined here. Huh? Judgment, yes, you can say that judgments are there, but it is not said there. The section 154 defines the affair. Deals with the affair. Provision of affair is deals under section 154. Definition and deals of the provision is something different. Murder and culpable homicide. In general term, both are same, but there is difference. So, if we go to the affair, definition of affair, what is an affair? Yes, report of an information. FIR, first information report. First point of time after the happening of the offence. Information regarding a cognizable offence, report given to a police officer. So that is that affair. What is section 154 says? Provision of a person goes to the police station, gives an information regarding the cognizable offences. If it is in oral form, then it is reduced to writing. Or if it is in the writing form, it is accepted by the police. The information should be entered to a concerned book. After that, the free copy of the affair is given to the complainant. That's all the provisions are there. And another provision. After 2020, if there is an women-related offences are there, which is complaint, in that case, the complaint must be given to a women officer. Taken by a women officer. This is the provision. 154(3) says that if the concerned officer didn't receive the affair, in that case, he can give the substance of affair to the SP or higher authority. That's all. But the question is, can a police officer deny to accept an affair regarding a cognizable offence? No. It is said in the Lalita Kumari versus Government of UP 2013. And if they do, it is an offense under section 166A or something. Okay, how I will see. zero error. Same question. Can a police officer or a officer in charge deny to receive the FIR under the circumstances by saying that it is happened outside of my jurisdiction, so I am not going to receive this thing? Yes. That is the zero error. That means he need to register that FIR by giving a number 00, and by that receiving that one, he has to transfer it to the concerned police station who has the jurisdiction. That is the zero error. And for the very first time, it is turned in this case, state of Andhra Pradesh versus Punadri Andhra, 1993 case or something.
It's not that doing that to national moving and forward is another station.
Yes, sir.
In case any protection need for harmful hours like there will take the protection of that person.
In zero FIR, they are treated as an original jurisdiction, but the transfer of that case is only official. It is not about the complainant who complained or they.
Protection power is like that's a good service of the protection power.
Yes, sir. The concerned police station. Yes, sir. Next, for the FIR is again, can you inform the police station and register an FIR? Yes, sir, we can do it, but there is some term and conditions are there. So, in these cases, Siddharth versus or Manu Sharma versus State NCR Delhi and K.T. Anthony versus State of Kerala. Into those cases and many other cases are also there where the court says that if an information which is received by a telephone, it must not be an cryptic information or a false information. If it is these two conditions, the two things are not there, then that particular information is treated as an FIR. So, if we take into consideration of the section 154 and those cases where regarding the your telephonic information are given, in those cases we club these things are common. That means there must be a detailed event. Nature of the attack, that means it is cognizable or not cognizable, place of occurrence, name, identity of the accused. Then 154 conditions must be followed in that particular telephonic information. In that case, that telephonic information is considered as an FIR. It must not be a cryptic one. That means you should not say some puzzle there and you need to give, or it should not be a wrong one. Okay?
Suppose I made a call and registered FIR. There is a provision in FIR that there is a magnetic which is the copy of this. And how did they give it the copy? WhatsApp.
No, sir. It is first, what is the object of the FIR? To initiate the criminal proceeding. Yes. By calling the police station, police are start the investigation is important or is the receipt of the copy is important? Which one is important? But if we are considering the object part, we should keep law into an motion. that is happening by the telephonic information that we needed. That is happening. Done. After the second error, it can be received later on of the investigation. If you are the victim, like I am face and road rage in Pakistan coming to the college. And I called the police in this particular place, like face a road rage by this person or by anonymous person. Please help me. Police come to you, start the investigation and all that. After that, if you are injured, take to the hospital. If you are not, take to the police station and take the information. In that particular point of time, they can give you the copy. Yes. When you are calling to a police station, that is, you are dialing 900. It is goes to a centralized, like that in films, Hollywood films, you saw that 911. Then you have to say your location and all that thing. So from there, they directly transfer into that concerned police station. This is yes, that is there is a centralized center or what you call it. Control room like things are there. They receive the call when you call 200. When they ask you what is your location, you told that okay in this some place like here. They transfer the information to the concerned police station and from there you get the help. GeoFair is when you are outside of the jurisdiction of the court. No, in GeoFair you are going to a different. Look, Mahapalli police station and Ll.B. police station. If we are considering between that area, some areas coming under Ll.B. police station, some are coming under the Mahapalli station. In those cases, you are with the confusion comes to the Mahapalli, where you have to register it in the Mahapalli. In that case, they cannot say that you are going to a wrong police station in zero. Out of bona fide intention or something is there, you are going there. And it is here in cause of action happened here, you are giving it in the hierarchy. It is not that. Properly reporting of the crime. Accurate reporting of the crime. In many cases, we as a normal person, normal human being, most of us don't want to involve in any legal proceedings. Okay, happened, okay, let it. We don't want to. That's another problem, one problem. Second problem, if we are involving in something, our social respect, we thought that if we have to go to the court, police station, all that thing, might be our respect in the society reduced. Social respect. Third, sometimes threats. Next, mostly in the women, to the police station or to the magistrate. So it becomes a problem for to get the data regarding the accurate reporting of the crime. Same thing. Is there? We already discussed. Please go through it. Done. Yesterday we are discussing the economic dimension of the crime. Mostly it's deals under the white color crime. So in 1939, for the very first time, the term was coined by Professor Argil, that is white collar crime. We already discussed why it is an white collar crime, because it is done by the some higher social status people of the society. Yes or no? So we can say that a person mostly who committed an offense which is mostly a scam, in any type of economic offense, that is done as a white collar crime. If you go to the definitions, you can find out that white collar crimes are not paragraph. White collar crime is the special type of solidarity from professional criminality, and it involves the real violation of the criminal law systematically or repeatedly by business, professional or clerical work in addition to their occupation. Those are the white collar crime. For an example, let's take an example of a bureaucrat who is in a higher authority and has the power to change the or modify to manipulate the system. And by doing that, I committed that thing. It is a white collar crime. So mostly, when the crime involves a betrayal or trust implied in holding of an office or position of the trust, bureaucrats or any other persons who are there. Take example of doctor, to whom he mostly trusted person, and for a gastric problem. Let example, there is a gastric problem, you have a gastric problem. You have an appendix problem. Same, both have the same type of symptoms. And for a gastric problem, if a person has operated your appendix, it can be, and you have to give 15,000 or 30,000 rupees, and it can be solved by 15 rupees each. So that is a white collar crime. For your personal benefit, professional benefit, you are giving a wrong treatment, wrong information, wrong remedy. That is mostly termed as the white collar crime. So what is the element? First, in the white collar crime, there is a violation. Violation of what? Violation of a directly or indirectly which is involved with your occupation, profession, etc. To gain money. Most of the time, the victims are not specified. For example, if you take the post scam, 2G spectrum scam, or that many scams are there. In that case, there is no specific victims. It is at large. That means sometimes we turn it as a no victims offenses, where there is no victims are there, because it is not targeted to a particular person. Maximum time. But sometimes the effect of sometimes the crime, this white collar crime can be committed by a singular person or by a group of people. Yesterday I think I gave you the example of that. Like to this spectrum. Whoever are there, they make a group and commit that scam. Example of that doctor. Singular person operated, instead of giving you he operated your appendix. So it can be done in that way. Now, come to the cause of the or motive of the white collar crime. What is, if in general, if I want to commit a white collar crime, if I want to commit a economic offense, what is the main objective, main cause of that thing? Earn money. Money attracts money. So if you have money, it attracts money. If you are a scammer, it attracts scammer. So first one, more and more profit, as I told, more and more profit, more money to accumulate it. Then, due to development of the scientific research and all, you cause something, and by that you have to get profit, or you want a monopoly in the business, or in that is also a cause of thing. Next, misuse of the post or occupation, whatever you are there. By economic growth or industrial revolution, take an example of the Chinese product. You can find out the same feature mobile, less cost, 10,000 rupees. Same feature go for the Apple or iOS format, 1.5 lakhs. No guarantee, no warranty type things. That is also a kind of scam we are facing. Regulatory measures and welfare activities taken by the government control the mean of the production and distribution of earth. Common good gives rise to violent crimes. Most of the time, because those who are the scammers, they can find out the loopholes made in the law by the parliament or by the legislation. If I say that, like you guys, some are there who comes, show their face here, sneak out during the class, and again reappear during the attendance. You find out the loophole. So, same thing if it happened in the industrial time, you find out a loophole in a particular law and you are doing that scam. This is also last one. There is passiveness from the public. How many of you find a complaint in the 2G scam? Nobody. Why? It is not happened to us. Why should we take care of that thing?
That we doesn't know.
What is 2G scam?
Yes.
also a most important cause or motive of the scammers. That means, as or the white collar criminals, as we are not targeting a specific person, there is no victim. Victim is the society. And as the society is the victim, nobody is coming to fight a case against us. So we are free to do that. That is one of the most important reason or motive of that person, white collar criminals, to commit that crime. If I am committing anything, nobody is the victim. Nobody is the victim. Who is coming to complain against me? In respect of the people, of general public, they don't do anything to us. Why should we file a case? Whatever. Any scam you do for an example, whatever the scams happened till now, your Commonwealth Games scam, 2G spectrum, coal distribution scam, or now that they are saying that Adani scam, all that scams, those are, it is not directly effective, so why we are going to find it? That passiveness from the general public is also given motivation to the criminals.
That one community against them, very complaints from public. Yes, it is. No one complains.
Secondly, your section 190 of CRPC also, sir. Court can take or initiate the case so moto by subclause 1 or 2. And most of the time, same thing is happening. When there is no victim, is there or some such kind of things are happened. Court most of the time take so moto cognizance and file the case from themselves and initiate the case. Some years before, given in Tamil Nadu, Sitkasi case. Sitkasi, you know then where the firecrackers are made. Shiva. So in that place, they appoint the minor kids to do all that work. Crackers and all that thing, they will see. So for that reason, court takes so much of cognizance to says that a child below 14 years you cannot directly involve them in the any kind of work, not only the dangerous work, any kind of work you cannot directly involve them in. So much of cases was there. Same thing happened in your scam, so whatever you are asked. Court can take the so much action. 190 CRPC. Source is not over till now, sir. Picture of the Gandhi. So next, what is the effect if it is not directly affecting us? So what is it affecting? It is affecting the economy of the country, economy of the nation, moral of the people, and some other things are also. First one is society, that means moral of the people. You can find out that many industrialists or that corporate sector in China, what we call them, they get the loan, they get the excuses, they can give the excuses and makes a lenient to them. But if a farmer is taking a loan of some 1,000 rupees and he cannot repay it, it is an offense. Due to that, he is committing suicide. That is degrading the moral of the society. Same thing, crime against the society, because if take Vijay Mallya, Nirav Modi and all that, those are absconded after taking the loan. It creates economic disbalance for which they need to increase the tax on us, to the middle class people, those who are paying the taxes. Secondly, economic disbalance. If take an example, yesterday I have also taken. Saying, what is the total budget of the country? Some lakhs crore. Out of that, if some 1,000 crores are gone after some person due to some scam, create vacuum or disbalance in our economy. So those are the some effects in of the white color crime. So this is for today. Next class we are going to discuss about the offenses regarding the drugs. Okay, thank you and have a good day.